Hi, I'm Ken Fossen. Today we'll have the fourth and final part of our review of the Nebraska Student Discipline Act. In this session, we'll be reviewing some miscellaneous provisions that were not presented in previous videos. To be more precise, we have 10 more things we want to discuss. So let's start our countdown. So far, we have discussed short-term suspensions, long-term suspensions, expulsions, and mandatory reassignments. But there is, of course, more to student discipline in the schools than these sanctions, and the legislature was aware of that. Section 79-258 provides as follows. Administrative and teaching personnel may take actions regarding student behavior other than those specifically provided in the Student Discipline Act, which are reasonably necessary to aid the student, further school purposes, or prevent interference with the educational process. Such actions may include, but need not be limited to, counseling of students, parent conferences, rearrangement of schedules, requirements that a student remain in school after regular hours to do additional work, restrictions of extracurricular activities, etc. We often hear references being made to the hearing room, but let me suggest that one room may not be enough. Section 79-273 provides that witnesses shall be present only when they are giving information at the hearing. Keep this section in mind when making the necessary preparations for a student discipline hearing. Since witnesses may be called by either party, you should make arrangements not only for the hearing room, but also for 2 additional rooms where the witnesses, who may despise each other, can be placed while they are waiting to testify. Section 79-283 provides that an expulsion that will remain in effect during the first semester of the following school year shall be automatically scheduled for review before the beginning of the following school year. This review shall be limited to newly discovered evidence or evidence of changes in the student's circumstances occurring since the original hearing. Although the Student Discipline Act gives the hearing examiner significant latitude in making a recommendation regarding the appropriate sanction for the given violation, that latitude does not always apply. Section 79-262(1) provides that the Board of Education may, by rule, specify a particular action as a sanction for particular conduct. Any such rule shall be binding on all students, school officials, board members, and hearing examiners. So, for example, if a school board adopts a rule that requires expulsion for any student who attempts to cause substantial damage to property, then the school administration and the hearing examiner have no discretion in the matter. They must expel the student if he or she attempted such an act. Section 79-262(2) provides that all rules and standards established by school officials shall not conflict with rules and standards adopted by the board. One surefire method that could be used to ensure that such conflicts never exist is to simply copy the Code of Conduct language from the student handbook and paste it word for word into the district's corresponding policies and rules. Section 79-262(3) provides that rules or standards which form the basis for discipline shall be distributed to each student and his or her parent or guardian at the beginning of each school year and shall be posted in conspicuous places in each school during the school year. Most, if not all, schools are in compliance with the first requirement, but attorneys are finding that some administrators are unaware of the posting requirement. So you might want to check to confirm that all of the buildings in your district are in compliance with that requirement as well. We often refer to the 5-day time period within which the student and the parent have to request a formal due process hearing. But what happens if the student and parent submit a request 2 weeks late? Section 79-272 provides that if a hearing is requested more than 5 school days, but not more than 30 calendar days, following the actual receipt of written notice, the hearing shall be held, but the imposed punishment shall continue in effect pending the final determination. Section 79-275 provides as follows. At a hearing, the student may speak in his or her own defense and may be questioned on his or her testimony, but he or she may choose not to testify, and in such case shall not be threatened with punishment nor be later punished for refusal to testify. Section 79-268(3) provides as follows. The Student Discipline Act does not preclude the student or the student's parent, custodian, or representative from discussing and settling the matter with appropriate school personnel prior to the hearing stage. With that in mind, the principal or superintendent may want to take advantage of every opportunity to visit with the parents and encourage them to communicate what's on their mind. Such communication can be beneficial in three important ways. First, the parents may have concerns based on misinformation. For example, the parent may think that the student will never get into college because his or her transcript will have the word expelled stamped in big red letters on its face. For this parent, sharing provisions in Section 79-2-104, which requires that disciplinary matters be kept separate from academic matters, may be enough to lead to a settlement without a hearing. Second, the parent may reveal their plans for the hearing. For example, if the parent says Johnny didn't do it and his friends will testify for him, you will be able to secure rebuttal evidence and be prepared for the hearing. And finally, the parent may indicate whether or not an attorney will be present at the hearing, and that will lead us to our final discussion point. If the parent represents the student, the defense will likely be focused on personal matters. He has never done this before. The punishment is too severe. Give him another chance. On the other hand, if an attorney represents a student, the defense will likely focus on legal matters related to the law. Did the school violate any of the material provisions of the Student Discipline Act? I think that a good way to describe the difference between a hearing with a parent and a hearing with an attorney is to say that the student is on trial in the former and the principal is on trial in the latter. An administrator who casually prepares for a student discipline hearing might do fine if the student is represented by a parent, but he or she could be crucified if the student is represented by an attorney. So always assume that the student will be represented by an attorney and prepare accordingly. That concludes our review of the Student Discipline Act. Thanks to the attorneys at Perry Law Firm for their assistance in planning, researching, and writing for this presentation. And of course, thanks to you for watching, and see you next week.